The recent cybersecurity disclosure requirements passed by the SEC have a lot of teeth to them. And I know that those of you who focus on cyber for a living, all of you from my past life, obviously are keenly aware of this, as are the people who focus on directors and officers liability, because this involves the SEC, which is a board level issue. But the IP people, lawyers and brokers that I know and work with, I don't think are as focused on this maybe as they should be, or maybe not connecting the dots. And I think that brokers and law firms, to be candid, from my own experience, are siloed such that they don't talk to each other maybe as much as they should. Why do I say that? Because this cybersecurity disclosure law really takes the question of whether or not organizations should identify and even value potentially their trade secrets off the table, in my opinion. There's a lot of debate about that. I feel very strongly about it already, but this newly passed cybersecurity regulation from the SEC makes it a no-brainer. And that's because you have to file an 8K within 4 days of determining that there's been a breach of your network that could materially impact your earnings, that could in the future potentially impact your earnings. 4 days from the date that you determine that it's material. When the SEC put out their guidance around determining materiality, they basically said that if it's anything that could damage your reputation or your competitive advantage, your competitiveness in the marketplace, that rises to the level of material. Trade secrets are your competitive advantage. They live mostly within R&D, except for the ones that are already out and being used, either within your own shop for efficiency purposes, or your clients are buying them and you're selling them, but a lot of that comes out of R&D. The companies, the top 10 companies on the NASDAQ just announced, or it was just disclosed, that in 2022, just in the previous year, they raised the amount of money that they were spending on R&D by 30%. Just those companies spent $222 billion in R&D. That's a lot of trade secrets living in an organization. They're not all trade secrets, obviously, but a lot of them are. And if you haven't identified those and you don't know what they're worth, at least relative to each other, how are you going to make a materiality decision and be able to file that 8K? Number one. Number two, more importantly, how are you going to respond when the SEC and the plaintiffs bar come after you, and your stock price drops and your shareholders come after you for failing to respond properly because you hadn't identified the assets at risk in the first place, or been able to demonstrate that you were ready, you could identify when they went missing, and you had a response to either get them back, seek damages, get an ex parte seizure, get an injunction, whatever it is that you're able to do to stave off, the future degradation of the value of your company or devaluing that asset. It's a big problem for organizations who are kind of turning a blind eye at, whether or not and where their trade secrets are. I know it's a big lift for people to identify all their trade secrets, and you don't have to try to find every single one, but at least categorize them and identify the crown jewels, the top 10 or 15%, that are the deal makers for your organization, that you've told your shareholders about, that you've gotten additional investment on the basis of. Those are material. The next thing is that you have to be able to disclose that you've got processes in place. Most organizations can't do that around some of their most material assets, which are their trade secrets, because they don't have a formal risk management process around those assets. We can help. We developed one specifically to be dropped into an ERM program for everybody from small to very large enterprises, so that you can say, yes, we have a formal process in place, and it's very rigorous around documentation and evidence, which is exactly what I think people need. And then finally, you have to be able to disclose in your quarterly and your annual report whether or not you've had incidents in the past that could result in a future degradation of the value of your company. If you don't know that you've had a trade secret compromise, how are you going to disclose it again? And so I think this really, it has a significant impact on intellectual property specifically, and that organizations, law firms, and brokers, and even internal general counsel and IP versus risk management, or in conjunction with risk management, everybody needs to be communicating and talking to each other about the impact of this issue, because I haven't seen one thing talking about the cybersecurity disclosure requirements impacting trade secrets, and that doesn't make any sense to me. It's huge. So hopefully we can help you. Obviously we have insurance for this for the first time ever. We would love to chat, so give us a shout if we can do anything else, and or if you have comments and you disagree or agree with me, I'd love to hear from you. Thanks.